Hello, my name is Helen Campbell, formerly of DG Skik and now retired. And today I'm going to make a speech for you about neighbours' disputes that become human rights disputes. I haven't started yet. Before I do, I'll just give you two names: the European Convention on Human Rights and the Tate Modern Museum in London. And I'm going to start now. As we all know, the European Convention on Human Rights was written after the Second World War. The object of this convention was to defend individuals from violation by the state. These are lofty principles in international legislation. And so you would think it very far removed from an argument among the neighbours. Well, such arguments are probably very familiar to you. They certainly are to me. I've had all sorts of problems with my neighbours. I had water pouring into my flat from upstairs when a neighbour installed a faulty plumbing system in a bathroom. The result of that was that the contents of the shower and the lavatory poured into my flat, and I can assure you that this really was no joke at all. I've also had to complain to neighbours about a dog barking all day, for instance, and again the neighbours having a party until 3 a.m. But I'm sure you know what I'm talking about, and you've probably suffered the same sort of problems. However, it has never occurred to me yet to invoke the European Convention on Human Rights. And yet, this is what happened in a small village, a quiet village, not far from London. Now, the protagonists in this story were property developers, and they took their neighbours to court. The neighbours were 3 pensioners and 1 local GP. The property developers demanded an injunction against alleged harassment and put in a claim for damages. A claim, a quite considerable one too, for £1.3 million sterling. Due to the loss of property value. That was the situation. And what were the objections? Well, those property developers had put in planning applications already for a summer house, a new tennis court, and some stables. And most of their applications had already been granted by the local council. Actually, human rights have been invoked in such cases before, so there is or was a precedent. Article 8 of the Convention is the right to respect for private and family life. And this was invoked by residents living close to the Tate Modern Museum in London, who claimed that the viewing gallery of the Tate Modern was so close to their homes and it overlooked, the viewing gallery overlooked their homes, and they felt, therefore, that they had lost privacy. However, this case was rather different. I have a question here. Do you think that neighbours have the right to complain, even if it causes general upset? Or another question, where does the balance between individual freedom and community interest lie? In all countries, there is some form of planning legislation. There are always restrictions on what you can build or what you can add on to an existing building, for instance. In this case, It seems that those property developers were simply hoping to ignore their neighbours' views. And the result was interesting. The judge invoked 2 articles of the Convention. Article 10, the right to freedom of expression, even if it upsets other people. And then Article 11, the right to peaceful assembly. Well, the result of this story was that the property developers lost the case and had to pay £200,000 sterling in damages. Now, many governments in the UK, especially Conservative governments, have threatened to leave the European Convention because they don't like the principles. In the end, most of these disputes are settled amicably and don't go to court at all. But if they do go to court, then the ideals should always be applied wherever needed, as indeed they were in this case. Thank you.